And thank you. So today we're going to talk about what happens after you receive the IHSS notice of action. We've given trainings to this group before about the IHSS program, in-home supported services program, which is a Medi-Cal service. And now we're going to talk about what do you do after you get a notice of action. So what we're going to do is we're going to look at what a notice of action is, what it should contain, and we're going to use a hypothetical to show you how this mother prepares for a hearing, what happens at a hearing, and after a hearing. So we're going to be talking today about Emilio. He's 12 years old, and he's a child with autism and auditory processing disorder. He's been receiving IHSS for a number of years, including protective supervision. But this year, mom got a notice of action after an IHSS reassessment, and it indicated that it was going to terminate Emilio's protective supervision. And the reasons it gave is because Emilio is self-directing and he does not need 24/7 supervision. Of course, mom is a bit confused because Emilio's situation hasn't changed. She doesn't understand why all of a sudden, after so many years of getting protective supervision, they now want to take it away. But let's talk about the notice of action that mom received. A notice of action is it's a written letter that's sent to people who apply for public benefit programs, or once on a public benefit, there's a change in the service, a notice of action is issued. So changes of eligibility, denial of service, reduction of service, termination of service, those are the situations. Eligibility for or take away eligibility, those are situations that would warrant a notice of action. There's a term in law that's called adequate notice. Adequate notice means that there are certain things that need to be in the notice of action. What is it that the county intends to do? It's in that notice of action because it says that they intend to take Emilio's protective supervision away. The reasons for the action, because he's self-directing, because he no longer needs 24/7 supervision. The notice of action should also include the regulations and laws the county is using, whatever guidance, whatever they're using to take the action they're taking. And the notice has to explain your right to a request for a hearing. And typically you have 90 days to appeal a notice of action. But if you are already getting IHSS, as in the situation of Emilio, mom can request aid paid pending. Aid paid pending means that if mom appeals before the effective date of the notice of action, not the date of the notice, but the effective date, when things are going to change for Emilio, when the county intends to take away the protective supervision. If mom appeals and before that effective date and asks for aid paid pending, when that date comes, that effective date comes, Emilio will continue with this protective supervision until there's a hearing decision, and hopefully the hearing decision is positive and Emilio will continue with his protective supervision. If you've asked for aid paid pending, you're going to most likely get another notice that reinstates what they were going to take away. Don't get confused. It doesn't mean that suddenly they've decided to give you the service back. It just means that they've instituted aid paid pending for now, because that's you might be surprised and think, oh, after you filed for a hearing and asked for aid paid pending, you'll get a notice that says your hours are being restored. That doesn't mean that they agree that they're going to give them to you. It just means they're restored during the aid paid pending time until there's a hearing decision. It means that your hearing will still go forward. So don't think that suddenly oh, they decided to give it to me again. That's not the case. So when we're looking at a notice of action, you've got a date here, notice date. So in Emilio's case, the notice was dated January of this year. Let's just say January 1st of this year. And down here, it'll say as of February 1st, 2024, Emilio's protective supervision is going to be taken away. Let's say that that's what the notice says. This is the effective date of the notice. The effective date of the notice is not the date of the notice. It's when the thing is going to happen. So starting, let's say, February 1st, Emilio's protective supervision is going to be taken away. And until there's a hearing decision, and if Emilio wins, he'll get his protective supervision back with retro pay. So don't get confused. This is the effective date of the notice when the change is supposed to happen, which is different than the notice of action date. And the notice itself, in the back of the notice, will talk to you about your appeal rights, each time you have a paid pending. Sometimes the notice of action will include something about the county still needs information from you. If that's the case, give it to the county so that they can, see the information and then determine whether or not they need to send another notice of action. So that's adequate notice. Also, if you've indicated to the county that you want notices and such in your native language, then you should get that notice of action in your native language. Now, let me explain. If you live in a county where your language is spoken by at least 5% of the population in the county, that's considered a threshold language. And the county has to give you the notice in your native language. If your language is not a threshold language, then the county and the county is not going to give you that notice of action in your threshold language. It has to provide interpretive services within 90 days of the notice of action. But you've got to let the county know that you need that interpreter, or the claimant already told the county that she wanted the notice of action in the primary language in the county and tells the county within 90 days of the notice of action. So you've either told the county or you're telling the county. So if you're, not to be confusing, but if your language is not a threshold language, then it's going to take longer to get that notice of action in your language. Don't let the time go by. Try to find someone who knows English in your language so that they could read the notice of action so that you can appeal, or more importantly, ask for aid paid pending, because that aid paid pending is a shorter time than the 90 days you get to appeal a notice of action. If you want to know whether your language is a threshold language in your county, you can go to this link and find it there. So there's another concept in law called timely notice, and that means that a written notice has to be mailed to you at least 10 days before the effective date of the notice. If it's mailed within 10 days of the effective notice, it's not timely notice. And that's, when you're appealing, you can just say, look, I didn't get timely notice. Sometimes notices are received after the effective date of the notice. And so how could you file for aid paid pending if the effective date came and went before you got the notice? In that case, you can just call the State Fair Hearings Division where these hearings are held and say, look, I didn't get timely notice and I want aid paid pending, and explain the situation, and they should allow you to do that. Okay. So how to file an appeal? Read the notice of action. many times I talk to people and they've gotten a notice and I ask, have you appealed? And they say, no, I don't know how. Well, it's because they haven't read the notice of action. So it's really important to read the notice of action. Also, I've included a website here from the California Department of Social Services. They administer the IHSS program statewide, where you can learn about the different ways that you can request an appeal. You can fax it in, you could phone it in, you can mail it in. I don't like to mail things because I'm not sure it's going to get to the recipient. So I always call in the appeals to the state fair hearings, and they usually give you a case number right away. If they can't give you a case number right away, call within 2 days of filing your appeal and request that case number, because that case number is proof that you filed the appeal. You can, if you're not quite sure whether you really want to go to a hearing, but at the same time, you really don't want the county to get away with the hours they gave you or didn't give you or taking away. I always say just appeal within the time allowed. You can always withdraw your appeal and not go to a hearing. And I've included a link to an all county letter. These are letters that are sent by CDSS to all counties about all kinds of matters related to IHSS, for example. And so this tells you how to withdraw from a hearing. It's really quite simple, but anyway, the document is there for you to look at. The appeals case management system. So in the case of Emilio, I'm going to stop sharing because we're going to go there. So mom can sign up to be able to manage the case electronically. So she can sign up through the ACMS system, and she'll have access at any time to the case file, the file that is with state fair hearings. When she's ready to upload her position statement and her evidence, she can do that through the appeals case management system. So it's up right here. It says you can access up above. The first link says you can access the system here, and then you would click that link. And then if you've already signed up, you're going to just sign on, right? But if you have, you create a username and a password, and then you sign on and you go case file at state fair hearings. If you want to create an account, you just hit create an account. And it starts to ask you questions. And then at the end of all of this, you will have access to the appeals case management system for your case. There you go. And you're going to create a username, a password. You're going to give an email, security questions. Looks a lot like when you sign up for, online banking or online stuff. And so it's pretty easy. So in Emilio's case, mom has signed up for ACMS, so it's easier for her to manage the file. You don't have to sign up for this. You can do this by snail mail if you want, or you can go to the county and submit the documents, or you can go, if you're going to have an in-person hearing, you could actually just take your evidence and position statement at the time of the hearing. If you're going to have an in-person hearing, a telephone hearing, you would want to call state fair hearings to find out how you can get your position statement and your evidence into state fair hearings, perhaps the day before the hearing. That's when you're not going to have an in-person hearing. But let me confirm, when you're having an in-person hearing, you can just take everything with you on the day of the hearing. Thank you, Mary. So that's the ACMS system. Like I said, you don't have to sign up for it, but it's there for you. Some people are not comfortable using the computer for this stuff, but for those of you who are, this is easy to use.
Maria,
Uh-huh.
I can also look and see what the county has uploaded, correct? To see
Exactly.
what
So
they're going to
any
use.
documents, right? Because 2 days before the hearing, the county has to provide you with its position statement and evidence it's going to use at the hearing. And you can all you have to do is, if you're on already ACMS, all you have to do is look at the file and you'll see everything there. Otherwise, you're having to talk to the appeals worker to figure out how you're going to get those documents. And I'll talk about that in a moment. But that's a really good point. You have access to the entire file through the ACMS electronically. So easy to manage. Thank you, Mary. So things to consider when you're appealing. Are you going to need an interpreter? You can ask for an interpreter at the time you appeal, at any time, even during the hearing. So if Emilio's mom, she thought she could do the hearing in English, but while she's in the hearing, she realizes that she's not understanding a lot of what is being said. She could stop the hearing and say to the judge, I need an interpreter. And the judge will try to find an interpreter, usually by phone. And if an interpreter is not available, then the judge will have to continue the hearing. One word about interpreters: poor quality for the most part, in my opinion, based on my use of these. And I don't hire these interpreters. The State Fair Hearings does. Had some very bad luck with interpreters where they're not interpreting properly. Because every word makes a difference. And so if you could bring someone to the hearing, a friend who knows both languages, to make sure that the interpretation is being done correctly. Because if it's not, you need to let the judge know, stop the hearing and say, we need to change interpreters. This interpreter is not doing it correctly. I said this and the interpreter said that. And the judge will find another interpreter. I mean, at a hearing where it took 3 or 4 times to get an interpreter, and we had to continue the hearings once or twice because we would start off with an interpreter, and even before the hearing, while the judge was giving instructions, and it was bad. And even the county objected to the interpreter. So it's not good out there for interpreters. If you are a person with a disability and need a reasonable accommodation, let's say that you're going to be there to represent yourself or represent a family member or friend, and you're a person with a disability and you need an accommodation, you should ask for it from the State Fair Hearings Division. Let's say, for example, I have a neurological condition that requires that I rest every 45 minutes for 10 minutes. That's what my reasonable accommodation would be, that, the fair hearing, you have to give me some time every 45 minutes to rest as an accommodation. There are many different kinds of accommodations. Maybe that the judge that the people who are in the hearing speak slowly. Whatever it is, the accommodation that you need. Subpoenas are, you're citing subpoenas of people, subpoenas of documents. So if you suspect or know that a certain person is not going to be at the hearing and you want that person to be there, or documents are not going to be presented at the hearing that you want to be there, you can ask the State Fair Hearings Office to allow you to subpoena the people or documents. And you can continue the hearing. Let's say that Emilio's mom has the hearing next week, but she's still waiting for medical documentation. And so she can call the Fair Hearings Office and say, look, I need to continue next week's hearing because I just don't have the medical documentation that I need. The first time around, the State Fair Hearings will say, okay, we'll continue the hearing, but any time subsequent to that you want to continue the hearing, you're going to have a really good reason for continuing. What's happening now with State Fair Hearings is that they're sending hearing notices and saying that you have a phone hearing. But you have the right to have an in-person hearing. So if you don't want a phone hearing, you need to call Fair Hearings Office and say, I want an in-person hearing. And they're going to say to you, okay, but that means that we're going to have to postpone the phone hearing and set up an in-person hearing. And you're going to say, fine, I want an in-person hearing. You can also ask for a video hearing, a home hearing. If the person who is receiving the IHSS benefit, wants to participate in the hearing, but can't leave the house, people can come to the home of the person or another location. You can have a hearing at another location. You can ask for an expedited hearing, that means you're cutting the line in front of everyone else who's waiting for a hearing. So guess what? You have to have a really good reason for expediting your hearing. A really good reason would be, for example, you need the services right now because you're at the brink of losing your home and going into a nursing home because you just can't take care of yourself anymore. That would be, in my opinion, a good reason for asking for an expedited hearing. Usually these hearings last a couple of hours. If you don't finish your hearing in those couple of hours, the hearing will be continued. I mean, I've been in hearings where they were continued 3 or 4 times before we were done with the hearing. Mary, you've been to a hearing too, so you can, if you have any words of wisdom, please let us know.
Thanks, Maria. I will. Thanks.
Okay. So what's going to happen with Emilio after mom files for a hearing? Well, Emilio's going to receive a letter from the State Fair Hearings Office confirming receipt of the appeal, letting Emilio's mom know that she will hear from an appeals specialist, and that later she'll receive information about the hearing itself, the date and time and place by phone for now, unless you want in person. And then later on, mom receives a letter from the appeal specialist. This is the person who's going to represent the county at the hearing. They're not attorneys, but they work for the appeals unit. And the letter from the appeal specialist is going to say, hey, I'm the appeal specialist. I'd really like to talk to you. Please give me a call. Call them, talk to them. I included an all-county letter about the responsibilities of the appeal specialist here, and they have a responsibility to try to resolve the matter short of going to hearing. So, matters have resolved at the appeal specialist level where you're talking to the appeal specialist. Maybe they want more information. Maybe they understand the case better and they change their opinion about the matter. And therefore you don't have to go to hearing. So that's a possibility. You learn a lot by talking to the appeal specialist. They'll learn about your arguments too and your evidence. So it's a two-way street, but it's worth talking to the appeal specialist and trying to resolve the matter short of going to hearing. And then at some point, Emilio's mom is going to get that date and time for the hearing. Now, hearings have procedures, right? You have the law that you have to deal with, and you have to prepare your case based on the law. But hearings involve procedures. And so there are two what do I want to say? There's the bench book, the administrative law judge bench book that talks about procedures. And there's also the manual of policy and procedures starting at 20-000. So we're going to go to these so I can show you what they are. So when you have a fair hearing, these manuals of policy and procedures are the rules to follow procedurally when you have a hearing. So for example, there's definitions, your right to a state hearing, how to request a state hearing, the time limit on the request for a state hearing, acknowledgement of requests for a state hearing, that letter that you get from the State Fair Hearings Office, setting a hearing, group hearings, hearing rules, general rules and procedures about evidence, about subpoenas, about if you're going to subpoena someone, they get to be reimbursed for fees and mileage, about how to postpone and continue a hearing, how to dismiss a case, how to disqualify a judge, disposition of state hearings, action by the director. I'm going to talk about that, notice of decision. So these are the rules, procedural rules on fair hearings. The bench book is a manual that the administrative law judges use at state fair hearings to help them carry out their work, right? So if we look at the manual, which we'll do in a moment, the table of contents talks introduction, abandonment. So when does a judge consider a case abandoned? Let's say that the person who filed for fair hearing, the claimant, doesn't show up at the hearing. How much time has to go by before the judge says it's abandoned? And what if the claimant now wants to resurrect the hearing? What has to happen? The judge can issue aid paid pending during the hearing too. But how does he do that? How does the judge handle continuances? What are the responsibilities of the counties? How does the judge get disqualified? What happens, judge, when you're in the hearing and there's a disruptive person in the hearing? What can you do? Under what situations do you exclude witnesses and observers? Ex parte discussions. You really can't have a one, if you're going to you can't really communicate to the judge privately. If you're going to communicate at all, you have to include the county. But you can't be communicating to the judge your opinions, your arguments. That's what you're going to do at the hearing. The explanatory remarks are the things that the judge is going to say before the hearing actually starts about, do you understand what this hearing is, that he's going to issue a decision down the line, and so forth and so on, swearing the witnesses, etc. On use of interpreters and oaths and postponements and recordings of the hearing. So the hearing is recorded. There's going to be a tape recording of the hearing. About rehearings, I'll talk about those. Anyway, so lots of good information, because although this is written for the judge, you get to learn the procedure too through reading these things. Thank you, Mary. Okay, so you've got the links to the regulations and the ALJ bench book right there. Okay, so now mom has filed for fair hearing. She got the state fair hearing letter telling her that there's going to be an appeal specialist. Mom will call the appeal specialist and try to resolve the matter with the appeal specialist. If not, then she's going to go to hearing and the appeal specialist will be there to represent the county. So how does mom start preparing for this hearing? The first thing she needs to do is identify the issues for the hearing. What's this hearing all about? Well, if you look at the notice of action, you know what it's about. It's about the loss of protective supervision, or the potential loss of protective supervision, because the county is saying that Emilio is self-directing, that Emilio does not need to be supervised 24/7. So the issue is pretty clear for mom that this involves the potential loss of protective supervision for those two reasons. She understands that, but she doesn't fully understand what that means. And that'll be step number 2. But we're still in step number 1. Her conversations with the appeal specialist may help enlighten her. She can review Emilio's file. Remember those procedure regulations? So the regulation 22-051.1 says that she can go and review Emilio's file. And by reviewing Emilio's file, especially the form that the social worker used in the reassessment, there's going to be a lot of information which may be useful to mom. And I had mentioned earlier, the county has to provide mom its position statement, and that's a document that tells the judge and mom what the county did, why it's doing the law that is supporting what it does, and all the evidence that the county is going to use. And MPP 22, this MPP right here talks more about the county's position statement, and evidence and a witness list too. So it's all here. And if mom is already subscribed to ACMS, she just goes online, and 2 days before the hearing, everything will be there. Otherwise, mom is going to have to, if mom wasn't using ACMS, she would have to call the appeal specialist and figure out how she's going to get this information. Either they'll fax it to her, email it to her. She could go to the office and pick it up. Um, so,
Maria,
uh-huh.
I just wanted to add that when in one of the hearing that I went to, I thought it was really important to look at their documentation, and in 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 making that determination, we reviewed their narrative because they document their observations when they get from the time they get to the home. And in this case, there was a lot of misinformation in the social worker's narrative where she indicated that the individual consumer was dressed and groomed appropriately, which wasn't true. It was a child and he was in his underclothes. So it's really important to review that and kind of, point that out to them and say, why did you indicate this when that isn't correct?
Right, because what does that do?
Hmm.
It questions the social workers, how good an assessment the social worker did, right?
Right.
If the social worker got it wrong about how well groomed the child is, what else did the social worker get wrong? And those would be questions that you would ask the social worker during cross-examination, right? So you want the judge to start thinking about, well, maybe this wasn't such a great assessment, right? Because why is there this information that was wrong? Maybe there are other things that are wrong that um, you know,
Right. And another
and
thing,
so it could be helpful to the case.
yes, another thing that was also pointed out in that narrative was that the individual child is the one that called out to mom, and the child's nonverbal.
So
So
how
these
does a
are
child?
exactly. So
Yeah.
so these are things that when filing for a hearing, you really want to pay attention to.
And when you're reviewing the file, right, you're wanting to,
Yes.
like, yeah, place. I was, when I represented a child too, we reviewed the file, and there was, in the social worker's assessment, there was, mom had told the social worker about new behaviors. It wasn't in the file. She didn't note it down. And there was information in the report that was completely wrong. So, anyway, really important. Thank you, Mary. So, mom understands what the issue is. It's protective supervision. Now, when mom goes to the hearing, and she wants to talk about all the other things that she doesn't like about what's happened in the past, the judge is going to say, whoa, we're not here to discuss all those other things. We're only here to discuss the notice of action you appealed. And you appealed because they want to take away the protective supervision, and that's all I'm going to talk about. Sometimes you can bring in other issues, but the county has to agree. The county's not going to agree to bringing in new issues that weren't part of the case for the most part. So stick to your issues, be focused, don't veer off into other areas, because the judge honestly will stop you and could get a little exasperated. So very important to stick to the issue. Okay. So the county's position statement, like I said, you can get it through ACMS. They can mail it to you. You can pick it up at the office. I think they can even email it to you, and I believe also fax. This is an all county letter that talks about the county's position statement. Really important that you read that so you understand what you're going to get. Now, so mom knows what the issue is. Now mom needs to understand what the law is on IHSS protective supervision. Why are they saying that he's self-directing? Why are they saying that he doesn't need 24/7 supervision? Mom has never seen anything like this. All she's done is when the social workers would come to do reassessments, is explain Emilio's behavior, give IEPs, IPPs, and the protective supervision was always approved. So this is the first time she sees these things and she's not sure what they mean. But as she explores what the law is by reading, we have a publication on protective supervision on our website. We have also a manual on IHSS that includes about protective supervision on our website. The manual of policy and procedures here, these are the regulations for the IHSS program, and they start at 30-700. She can go to the regulations and search for the term protective supervision, and everywhere protective supervision is mentioned in the regulations, she'll find information. It talks about what it is. It talks about what it isn't. It talks about how many hours someone could get, depending on whether severely impaired or not. Also, there's an all-county letter, 15-25, that goes into a lot of detail about protective supervision. After reading all of these things, and Mary, why don't we go to the regulations on IHSS so people can see what that looks like? I'm going to stop sharing. So why is it with the Department of Social Services? Because CDSS administers the IHSS program. So you go to 30-700, start there, and then you're going to get you're going to have to go scroll up to the top. Yeah. So it starts off with a table of contents about what's in all of these sections. Definitions, special definitions, the health certification form, establishing need, time, program service categories and time guidelines, the application process, responsibilities, needs assessment standards, service authorizations. And if you do a control F, and you put in, Mary, if you want to do that, just do control F because you're going to search for protective supervision. You're going to find everywhere in the regulations where it mentions protective, you're going to find information in the regulations, and you'll eventually get to the there are 36 references to protective in. To be more precise, you can put protective supervision and you'll get directly, to it. But it's a way of, this is a way of finding information in the regulations. It's pretty easy because you're looking for the word, right? It says here, it consists of observing recipient behavior and intervening as appropriate in order to safeguard the recipient against injury, hazard, or accident. And if you scroll down to the next page, it says it's available. Protective supervision may be provided through any combination IHSS, alternative resources, voluntary services. It shall not be authorized for friendly visiting or other social activities. Anticipation of a medical emergency. So you can't ask for protective supervision because the person has, for example, epilepsy, and you're there to just, when the person has a seizure, to be there to do what you need to do. That's not what protective supervision is about. It's not to prevent or control antisocial or aggressive behavior towards others or things. And it's not there to guard against self-deliberate, meaning the person understands what they're doing, self-destructive behavior such as suicide, or when an individual knowingly intends to harm him or herself. And so it goes on. So that's the way you could use these regulations. For whatever question you have, you just do a search function for the word that you put in. Control F usually will get you that. And you just put in the word and there you go. Everywhere that word is in the regulations, you're going to find it. So there are many ways to find out about the program through our website, through CDSS, and through all these. So mom now understands what the notice is saying about protective supervision. Hold on, I need to do this here. Make it nice. Okay, so she now understands that there's criteria for getting protective supervision. She never knew this. You have to show that the person is non-self-directing due to a mental impairment or mental illness. What does it mean? It means that because of the person's mental impairment, it could be developmental, it could be psychiatric, it could be traumatic brain injury, dementia, Alzheimer's, whatever the mental impairment is, because of their mental impairment, the person doesn't understand that the behavior that the person is about to do or is doing will cause him or her injury. It's to protect the person from him or herself, nothing else. Protective supervision is not to protect others from the person's aggressive behaviors. So remember, the notice of action for Emilio said he is self-directing, that he does understand that his autism and his auditory processing disorder does not make him non-self-directing. He is self-directing. He understands that his behaviors are going to cause him injury. That's what it's saying. The second criterion is that the person can engage in potentially dangerous activities. If you physically can't get into dangerous activities, you're not going to get protective supervision. You don't have to get injured to get protective supervision, but you have to have the potential of physically getting into danger, right? The third criterion for protective supervision is that the person needs to be supervised 24 hours a day, 7 days a week. The program doesn't pay for that amount of time, but that's the requirement for protective supervision. So now mom understands why the notice says he doesn't need to be supervised 24 hours a day, 7 days a week. For children, for minors under the age of 18, there's a fourth criterion, not for adults, but for children, you have to show that the child of that age, so Emilio's 12 years old, with disabilities, a child of that age, you compare that Emilio with a child of the same age without a disability, and you have to establish that Emilio, because of his disabilities, needs more supervision than a typical child age 12. That to me is the easiest thing to do when you're talking about behaviors, where you're describing what the person is doing, the self-injurious types of behaviors. That is an easy criterion, in my opinion, to meet. So mom understands that the county is using 2 of the 4 criterion for a minor to take away the protective supervision. Okay, so now she understands the law. On the State Fair Hearings website, there's a decision registry. So you can look up decisions, IHSS decisions. And so you can go here and look up the registry and put in information, and then you're going to get cases that have been decided on that particular issue. If any of you have gone to regional center hearings or special ed hearings with the Office of Administrative Hearings, on the Office of Administrative Hearings website, you can also see past decisions for special ed and past decisions for regional centers. So State Fair Hearings has something similar with the decision registry. Okay, so now mom understands the issue for the hearing. She understands that there is criteria that needs to be met for protective supervision. So now she understands what the 2 reasons are for taking away the protective supervision means. It's criteria. Now she needs to identify and gather evidence that will show the judge you know what? He's still non-self-directing. You know what? He still needs 24/7 supervision. And by the way, there's something called the burden of proof. So when like Emilio has been on IHSS protective supervision for years. And last year they approved him for protective supervision. This year they're taking it away. So the county has the burden of proving that things have changed between last year and now to take away the protective supervision. So the judge is going to want to know, county, tell me, last year you approved him for protective supervision. What evidence do you have now to change that decision? And the county is going to say what, is going to bring up some evidence. Maybe it's good evidence, maybe it's not, but they have the burden of showing that there has been a change so as to take away the protective supervision. If what they're relying on is flimsy, they should not win. But mom also has to be prepared to explain to the judge that he continues to be non-self-directing, that he continues to need 24/7 supervision and gather evidence for that. How does she do that? She can look at the IEPs, maybe the triennial, the IPP from his regional center. Make sure, don't just give documents to give documents. You need to make sure that all of the documents that you're going to submit as evidence tell the same story, right? Because if in the IEP it says that Emilio only needs to be supervised per mom, Emilio only needs to be supervised while he's at school, and the IPP says Emilio needs supervision all the time, and mom has signed both documents, who's the judge to believe? You've got conflicting evidence that you've provided. So you need to make sure that all of your documents are factually consistent, that they're not, in conflict with each other. The other thing that mom's going to want to do is get a letter from the doctor, get records from his doctors to see if there's any good information there that will help her establish that he needs 24/7 supervision, establish that he's still non-self-directing because of his disability. Now, if mom were to say to the doctor, oh, I need you to prepare a letter because my son needs to be supervised all the time. Can you write a letter? Well, the letter is probably going to be a very not so good letter because the doctor may not understand that there's criteria for protective supervision. The doctor may have another idea of what protective supervision is. I've seen those letters and they're not really very good. So if you're going to ask a doctor to prepare a letter regarding protective supervision, the doctor has to address the criteria in question. If it's a new case and you're just preparing, oh, sorry, I'm going to sneeze. It's the first time that you're asking for protective supervision, you're going to have to establish why you meet the criteria for protective supervision. And the doctor needs to know the criteria, needs to understand the program in order to write a good letter. So a good letter will say, I've been a doctor for Emilio for the last 7 years. He's a child with autism and auditory processing disorder. His disabilities make him non-self-directing in that he doesn't understand that the behavior, you use the language that the program is using. He doesn't understand that the behaviors he engages in or is about to engage in can cause him injury. Let me give you some examples. And the doctor should have in the letter examples of behaviors. And guess what? Who's he getting those examples from? From you, the parent. So when you go to the doctor's office and the doctor says, well, how's it going? You need to start talking about those behaviors because otherwise the doctor has nothing to say in the letter because the doctor doesn't know about the behaviors that are happening at home or wherever. So, that he needs 24/7 supervision because, he gets up at night and and during the day, these behaviors can happen at any time. Let me tell you a time when, he was asleep and this happened. He got up and left the house and the police were called and they found him 4 hours later and he was crying and disoriented. He didn't know where he was. Um, 24/7 supervision, right? So that's really what a good letter will look like. The SOC 821 is a form that the county requires a doctor fill out where it identifies the functional limitations of the person in memory, orientation, and judgment. It shall not be determinative. So even if the doctor checks severe in these three categories, it doesn't mean that the person is going to get protective supervision. This document, along with all the other evidence that the social worker gathers, will determine whether the person will get protective supervision or not. And if you don't submit an 821 form, then the county will use whatever other evidence they have to establish whether or not this person should get protective supervision or should continue getting protective supervision. So that's another form that mom has, but it's severe in all categories, but that in and of itself is not going to give him protective, it's not the answer to continuing with protective supervision. It's just a document. It's going to be considered with other documents. So Emilio has an ABA provider. Mom can get a similar letter to the doctor's letter from the ABA provider. You know, the ABA provider jots down what happens during each session. There might be information about behaviors that Emilio exhibited that were self-injurious or could have been self-injurious to show he's non-self-directing, and that this happened, you know, during the day or in the afternoon, whatever, to establish the need for 24/7 supervision. Witnesses, maybe there are neighbors, family, friends who can talk about this where they observe behaviors that clearly identify that the person is non-self-directing. So, for example, maybe, you know, there could be witnesses that talk about Emilio getting up on top of the counters and jumping without any understanding that he could get hurt that way, or eloping from the house and getting lost, or banging his head on the wall without stopping because he doesn't realize that if he continues to bang his head on the wall, he's going to get hurt. Or self-injurious behaviors in the scratching and scratching and scratching himself until he bleeds, and he won't stop until someone stops him, because he doesn't understand that if he continues to scratch himself, he's going to bleed. That could lead to infection and other complications. So these witnesses can prepare declarations. A declaration is a document signed under penalty of perjury. It's basically what the witness is going to testify to. If you're going to have a phone hearing, you're going to let the judge know, and you're going to have witnesses. The judge is going to want to know the name and the phone numbers of the witnesses. So when the judge is ready to hear the witness, the judge will call that person by phone. The witness can be in person too. The witness can come to the hearing. If you're going to have an in-person hearing, you can have the witness testify by phone. You just need to let the judge know in the beginning that you're going to have a witness testify by phone. What happened at the home evaluation may be important, like Mary mentioned earlier about reviewing the assessment that was done by the social worker. You know, there may be a lot of information. There are some information there that's just wrong. I always say, when you're going to have an evaluation, have someone there present who can write down what was asked, what was answered, the length of the evaluation, how much time was spent, you know, signing papers versus really the social worker asking the kinds of questions to establish need, right? Because that is someone who could be a witness to at a hearing. Emilio's mom has never heard of a hazard log, but she started to create one after she asked for a hearing. It's a day-to-day log that jots down the date, what behavior it was that Emilio did or was about to do, what kind of intervention was needed, was he injured, was he not injured? Like I said, you don't have to be injured to get protective supervision. If there was an injury, take photographs. If there's a behavior that's happening and someone can videotape the behavior, you can submit videos at the hearing to show everyone just what the non-self-directing behavior. I wouldn't say if you're the only person there, take a video of the person while they're having the behavior, because you really don't want to, you want to prevent the behavior. So if there's anyone else who could take that video, that could be a piece of evidence. If you're a regional center client, there's a form called the CEDAR that talks about the person's memory, judgment, confusion. That may be helpful. Incident reports. So if there's been an incident report, Emilio, when he eloped at night, they found him 4 hours later, the police were called. Mom may want to submit that incident report about his elopement. Probably other things that you could submit, but these are just things that mom is thinking about and trying to gather so that she can submit them at the hearing. The next thing that mom is going to want to think about is whether she wants to prepare her own position statement. She's going to get one from the county. Does she want to prepare her own position statement where she tells the judge that she disagrees with the county's notice of action because Emilio is not self-directing, and this is the evidence that she has to prove it. Mom can be a witness too, mom and dad. Mom can testify as to all the behavior she's witnessed to support the fact that he's non-self-directing, to support the fact that he needs 24/7 supervision. So the position statement would be her argument as to why he continues to require protective supervision. And she can attach her evidence to that position statement. If she doesn't have a position statement, then she'll have her evidence. Evidence comes in two forms. Oral evidence, which is the testimony at the hearing, which is recorded, and written evidence, which is the evidence that the judge allows to come in as evidence for the hearing. So if mom is not going to have a position statement, or even if she is, she should make notes about what she wants to cover during the hearing so that at the end of the hearing, when the record is closed, she doesn't say to herself, oh my gosh, I forgot to say this or ask about this. Just have a checklist of the things you want to cover to make sure you cover them before the end of the hearing. If mom is going to have an in-person hearing, she would take, if she wants a position statement, she can take her position statement and her evidence on the day of the hearing. If she's going to have a phone hearing or any type of other hearing where it's not in person, she needs to coordinate with State Fair Hearings as to how she's going to get her position statement, if she has one, evidence definitely before the hearing. So the day before the hearing, she might need to fax it in. But in this case, mom is subscribed to ACMS, so she can just submit it electronically. It'll be easy for her. So that's something else mom is going to have to think about. The next thing mom is going to have to think about is preparing her questions for the social worker. Those are be cross-examination questions, like what Mary was saying about, why didn't I told you that this and that, but in your assessment, in the records of my son, it says something different, or you failed to put that information in your written assessment. Why did you do that? So, questions to the social worker, or how did, what is your education, or, how are you qualified to determine whether someone is non-self-directing? Because isn't that the job of a medical professional, psychologist, psychiatrist, neuropsychologist? Isn't that someone with some expertise? What kind of expertise do you have to establish that, that Emilio is non-self-directing? Do you know what autism is? Do you know where in the spectrum he is? Do you know about auditory processing disorder? Do you know about his auditory processing disorder? So you start to ask questions that really the judge is like, how did she, she doesn't really seem to know much about the disability, about, the things necessary to make a determination that Emilio is non-self-directing. If mom has any witnesses she's going to have to, that are going to testify, she's got to ask the questions, right? So you're a neighbor, yes. And um, um, on, September 2nd, you were woken up at night. Yes. What happened? And then the witness is going to testify, well, I heard the police in front of the house and I came out and I spoke with you and you told me that Emilio had escaped and we were all concerned and the police were there. Um, I stayed with you and until Emilio came back home and he was disoriented and confused, and he doesn't have to be disoriented or confused, but he was in this case. And they found him, 5 miles away. That's a witness for the fact that he needs supervision at not the 24-hour, 7-day a week supervision criteria. Also that he's non-self-directing. He's someone that if he leaves the home won't doesn't know how to get back home, doesn't know that by leaving the house he's going to get lost and things can happen. There may be other witnesses that the county brings in, and you're just going to have to, be ready to ask questions of those people about their ability to give testimony about the things they're saying. Like, do you even know my child? Have you ever even evaluated my child? And so how can you say that, he's self-directing? What documents did you read to establish that he was non-self-directing? One of the questions I would ask the social worker is, so, you've seen the Emilio's doctor's letter that says that he's non-self-directing, that he continues to need 24/7 supervision. This is a doctor that has treated Emilio for 7 years. This is a doctor who really knows Emilio. Are you saying that that his treating doctor shouldn't be given deference for his opinion? You social worker, you probably saw Emilio for an hour and you're determining that maybe based on your visual observations of an hour that he doesn't need protective supervision. Well, you're not there those other 23 hours in the day. Did you look at this? Did you look at that? So what you want to do with the social worker who made the determination is really to question their ability to come up with those determinations. Like in this case, is Emilio self-directing, that Emilio doesn't need 24/7 supervision? At some point before the hearing or even at the hearing, there may be an offer of a conditional withdrawal. So let's say that it's before the hearing and the appeal specialist says to mom, we want to reassess Emilio for protective supervision. Would you be willing to enter into a conditional withdrawal? And we'll take the hearing off calendar. Mom has choices. She can either say to them, look, you had the ability to assess him properly when you came to the reassessment. I don't want you to reassess him again. I want to go to hearing. And she can just say, I'm going to go to hearing. I'm not going to enter in a conditional withdrawal. Or she can say, okay, I agree to that. And they have to do the assessment within 30 days of signing the conditional withdrawal. And let's say that they do, and that they issue another notice of action with the same result, that they're going to take away the protective supervision. Just because you agree to a conditional withdrawal doesn't mean that you're suddenly going to get what you want. You may find yourself again asking for a hearing. So sometimes appeal specialists will call you and say, look, we agree that in this case that Emilio continues to need protective supervision. Will you enter into conditional withdrawal where we reinstate the protective supervision? Make sure mom has to make sure that they reinstate if there wasn't any aid paid pending, that they reinstate from the time that they took it away. If you have aid paid pending, there's no retro because you've been getting it, right? Really important The MPP on conditional withdrawal is here, and you've got access to that. There's the link that I showed you. At the hearing, nothing like this. This is more either superior court or federal court setting where you have the judge with the robe and the jury and the attorneys and the witnesses, whatever, or the defendants, whatever that is. Not quite sure if this one here is another attorney or the plaintiff, but anyway, no, you're going to be in a room, and usually a small room, and the judge is seated at the head, and one side, the county will sit, and the other side, you will sit with your people, and the county with its people. Who's going to be at the hearing? The judge who's going to decide the case, the appeal specialist representing the county, maybe the social worker who did the assessment will be there, and or a supervisor, and or a nurse, a doctor, who knows? You will be there, the claimant. Maybe you have an authorized representative, and if there's an authorized, if you want to bring someone to the hearing to represent you on the day of the hearing, that's fine. You're going to have to fill out a form, and the judge can give it to you to fill out. Any witnesses will be at the hearing. Usually what happens when witnesses testify is that all the witnesses are asked to leave the room except for the one that's giving testimony, and they do it one by one. The interpreter will be there if you've requested an interpreter. So the room can get pretty crowded, with all these people there. I've talked about the record. What is the record? The record is the evidence, oral testimony and documents that were entered into evidence. What does it mean, entered into evidence? It means that the judge agreed that that evidence could be presented in this case. If while Emilio's mom is at the hearing, she realizes that there was a document she should have brought that was really important for this case, she could say to the judge, Your Honor, can you leave the record open so that I could submit this document? And the judge will say, because there's a certain time that the state fair hearings has to submit a decision. And if they go beyond that time, they owe you money. It's a penalty. So the judge will say to you, will say to Emilio's mom, okay, you want me to leave the record open, then you need to agree to waive the timelines for the decision. I would. I'm more interested in getting that piece of evidence in than getting any money penalty from the state. So, and the judge will say, okay, to Emilio's mom, I'm going to give you a week to submit that document, and I'm going to give the county another week to respond to that document. And then I'll make a decision. I'll be closing the record in 2 weeks, and he'll give a specific date. He'll give a specific date for you to submit that document, and he'll give a specific date for the county to respond. Why is the record important? Because if you're not happy with the decision, your next level of appeal is to the Superior Court of California, and you're going to be filing a writ of administrative mandamus. And the Superior Court judge is going to look at the record to decide the case. Rarely will new evidence be submitted. It's all based on the record at the administrative level. And so the record is important, especially if you're going to appeal. The general sequence of events, I've been to hearings where it's not so much like this, but because there are judges who are very proactive. They're in asking questions, making sure the judge is getting what he needs or she needs from the testimony. There are other judges that are very reserved. They hardly participate. They're just listening to people and to witnesses. You get all kinds of judges. So, general sequence of events, the judge will give an overview of what's going to happen, swears in the witnesses, reviews the evidence that both parties have submitted, and if there's any objection by any party, that will be discussed. And then the judge will decide what evidence comes in. Then he or she is going to turn to the county and say, explain your position. And the county will explain what they did, why they did it. and call witnesses, maybe the social worker or someone else. And the appeal specialist will ask the social worker, what are the questions about? The questions are about what changed between the last time you gave protective supervision to this time? What is your evidence to show that, right? And then once the social worker is done and there's no other witnesses, then Emilio's mom can cross-examine the social worker at that time or any other witnesses who testified. Then the judge is going to turn to mom and say, tell me what your position is. And mom is going to say she disagrees, why she disagrees. And if she has witnesses, she's going to question the witnesses. And the appeal specialist is also going to have the ability to cross-examine your witnesses. And by the way, the judge could be asking questions of the witnesses too. That happens. So there's not just a one size fits all. It could vary depending on the type of judge that you have for you. The county's responsibilities at the hearing, remember those regulations about procedure, summarize the written position statement, examining county witnesses, cross-examining your witnesses, responding to any questions from you or the judge concerning the case, having the case record available at the hearing, the burden of going forward in the hearing to support its determination. This is very important. Having the authority at the hearing to make a binding agreement on behalf of the county. Sometimes it's happened to me before where the judge will say, I want county, I want you to reevaluate this person. And we decide, okay, so the county's going to reevaluate. It's kind of at that point, what's happening, in my opinion, based on my experience, is that the judge is really saying to the county, you guys may have missed the point here, and I'm giving you a chance to redo this. Sometimes I also think it's a way for the judge to not have to come to a decision and do all that work, but put it back on the county to come back with something better, perhaps. Who knows? In any event. What happens after all of the witnesses have testified? The judge closes the record. No more evidence can be submitted unless the judge left the record open, as I explained earlier. The judge, and then the judge will give instructions as to next steps, the decision, etc. And if he left the record open and gave you a deadline for complying, you need to do that. If you don't, the record closes. At some point, the judge is going to issue a decision. That decision can be changed. The director of the California Department of Social Services, actually the legal department of that unit, that agency, can change the judge's decision. So let's say the judge decided that Emilio continued, that the county didn't meet its burden of proof in wanting to take away the protective supervision. The director of CDSS can change the judge's decision and say, you know what, the judge was wrong. Yes, there was the county met its burden to take away the protective supervision, but the director can't just say that. There's got to be a legal basis for that, right? And so if that happens, then Emilio's mom is going to get the judge's decision and it's going to have void on it. And on top of the judge's decision will be the alternated decision from CDSS, and that'll be the final decision. Now, the decision will have your appeal rights. Remember, I said you have your next level of appeal is a writ of administrative mandamus with the Superior Court. You have 1 year to file it. If you win, you can ask for attorney's fees. This is the only instance you don't get attorney. If you have an attorney at administrative law judge hearing and you win, you're not going to get fees for that to pay your attorney. You have to pay your attorney yourself. You don't have to have an attorney to go to an administrative law judge hearing. But before, as you're contemplating whether you want to go to Superior Court, you might want to ask for a rehearing And the decision will also ask you, will also tell you how to ask for a rehearing, the time you have to ask for a rehearing. If you are asking for a rehearing or you're going to appeal to Superior Court, you could call the State Fair Hearings Office and ask for a copy of the recording of the hearing. You're going to want to do that because if you're shopping around for an attorney to represent you in Superior Court, that attorney needs to review the record. Remember, the record is the testimony and the written evidence that was used at the hearing before that attorney decides whether he or she wants to represent you in Superior Court. For the rehearing, it'll be important because if you're granted a rehearing, it doesn't have to happen. They don't have to grant you a rehearing. If you are, you're going to want to know, you're going to want to get the testimony that happened in the first hearing. So getting the record is important. Getting the recording is important. About rehearings, there's a section in the regulations on procedure 22-065. You have to request a rehearing within 30 days after receipt of the decision. You have to state why you're asking for a rehearing, state the date that the decision was received, because they're very strict about these 30 days. And if you want to introduce new evidence, you have to describe and submit the new evidence, state why it was not submitted at the first hearing, explain why it's material, why it's relevant to the hearing, and how this evidence is going to change the decision. Like I said, they don't have to grant a rehearing, and the decision will actually tell you where to send it. There's a rehearing unit, but while you're waiting to hear about the rehearing, the time to file a writ of administrative mandamus is still ticking. Just because you've asked for a rehearing doesn't stop the clock on your appeal to Superior Court. It keeps on ticking. So that's really important to know. So after the hearing, complying with the decision, another regulation on procedure, it says immediately upon receipt of the decision that county has to initiate compliance. And it has to, within 30 days of receipt of the decision, submit a compliance report to State Fair Hearings. Sorry, I didn't mean to do that. If the county hasn't complied with the decision or partially complied, or you're dissatisfied with the compliance, you can contact California Department of Social Services. I would contact, or I'd probably contact State Fair Hearings and complain. And then upon notification that the county failed to comply or is not complying completely, State Fair Hearings and/or CDSS will take appropriate action to make sure the county complies with the hearing decision. So we've come to the end of the presentation. I'm happy to answer questions. This is our intake line. So if you have any questions about IHSS or things that we do, like special ed, regional center issues, disability discrimination, you can call us and see how we can help you. And this is our website. So if you want to go to our website, we have publications on our website about a lot of issues. There's a lot of information on about us on the website too. So